All right, civil law. Concerned with rights and duties of private persons and citizens, administered between private persons, and enforced through courts as damages. No fine or imprisonment is assessed. Public law. This is concerned with the state and its political capacity, centered on the relationship of the person to the state. So criminal law addresses conduct that is harmful or offensive to society. It's an example of public law. Legal actions brought by state, city, or administrative bodies, and punishment ranges from fines, imprisonment, to execution. So substantive law. This defines the substance of the law. It's classified into civil, administrative, and criminal law. Concerns the wrong, harm, or duty that caused the lawsuit. Procedural law governs the procedure to create, implement, or enforce substantive law. It concerns the rights of the defendant. Due process of law protects right to life, liberty, or property. It applies to state actions, not those of private citizens, and it's founded on principle of justice and violated if laws operate unequally among persons.
Substantive law defines rights and duties, such as crimes and punishments in the criminal law and civil rights and responsibilities in civil law. It is codified in legislative statutes, can be enacted through the initiative process, and in common law systems it may be created or modified through precedent. Substantive law stands in contrast to procedural law, which is the machinery for enforcing those rights and duties. Procedural law comprises the rules by which a court hears and determines what happens in civil or criminal proceedings, as well as the method and means by which substantive law is made and administered. However, the way to this clear differentiation between substantive law and serving the substantive law, procedural law has been long, since in the Roman civil procedure the actio included both substantive and procedural elements.
What is statutory law and what is procedural law? Well, again, these are just definitions or categorizations of law. Substantive law, as the name implies, has substance to it. It is the law that prescribes or details the conduct that cannot be done or can be done. It's generally found in your statutory law. And it, like I said, it either prescribes or mandates conduct. Where procedural law is generally the method for carrying out that rule or regulation. Oftentimes it's found in the regulations, but it's more of a method or manner of applying the law rather than the actual law itself. So if you were to think about this in the context of a trial, procedural law would be that, say, you have to answer a complaint within a 30-day period. Well, that's a procedure, so it's a procedural rule, okay? Where, on the other hand, a law that says you cannot knowingly take someone else's property without their consent, well, that would be a substantive law. So again, conduct mandating or prescribing, a law mandating or prescribing conduct is substantive. Procedural is how you go about carrying out that law.
So equal protection of the law restricts states, not private actions. Its reasonable classification of persons must be treated similarly. Rules and regulations may not be based on race, religion, or gender. So questions of fact. Fact finder weighs admissible evidence. Facts are determined by evidence. Fact finders are final authority on credibility of witnesses, and a judge serves as fact finder in trials without a jury. So questions of law, application or interpretation of laws are determined by judge. They consider statutes, rules, and regulations, prior court decisions, new technology, and societal needs. So what is jurisdiction? So jurisdiction is power and authority to hear and determine a judicial proceeding. So what that means is who can judge what area of something. So subject matter jurisdiction, that's the res jurisdiction, personal jurisdiction, and then territorial jurisdiction. So for overlapping or concurrent jurisdiction frequently occurs in cases when there's more than one defendant. The plaintiff's attorney may advise an optimal court, and the plaintiff is the person who's making the complaint. So in the state courts, there's trial courts, and that's the court of original jurisdiction. There's state appellate courts, and this is where the losing side can appeal to. And then the state Supreme Court has final authority. Unless constitutional rights are involved, then it can go to the U.S. Supreme Court. Federal courts, we have district courts, so that's a court that cases involve a federal question. The Court of Appeals, which is the U.S. Circuit Court, and that can be correct errors made by a trial court, so a place where you appeal. And then the Supreme Court's the highest level, and these decisions are binding. And then statutes of limitations, procedural law timeframes, continuous treatment timeframes, and discovery rule.
Different from personal jurisdiction. Both have constitutional roots and both create a potential absolute bar against a court hearing a given dispute. But they play very different roles in our judicial system. Personal jurisdiction is there to protect defendants. Subject matter jurisdiction is there to limit the authority of courts, to protect society at large, and to protect the government from itself. The role and purpose of subject matter jurisdiction significantly affects its scope and governing rules. And if you understand the policy and the policy differences between subject matter and personal jurisdiction, the practical and legal differences between the two will make a lot more sense. For example, personal jurisdiction is waivable. Subject matter jurisdiction is not waivable. Where a court has no subject matter jurisdiction, it simply lacks the authority to hear the case. It's no different, for example, than a plaintiff and defendant coming together in Macy's, grabbing another shopper, throwing a black rope on her and calling her a judge. Taking a bunch of other shoppers, putting them in a corral and calling them the jury. They can hear the dispute, they can listen to what the plaintiff and defendant have to argue about, but the judge's decision has no force of law. A court that lacks subject matter jurisdiction is much the same. It lacks the power to adjudicate an issue, and if it tries to, it inflicts an injury on society, and more than just simply an injury on the litigants, as in the case of personal jurisdiction. Simply, subject matter jurisdiction can be raised at any point, by any party, and even the judge. Personal jurisdiction must be raised by the defendant in his first formal response. The first formal response to the plaintiff's complaint. Here's a hypo, as an example of subject matter jurisdiction. Two corporations are involved in a patent dispute relating to a highly complex piece of biotechnology. The trial takes 2 months. The first 3 weeks of the trial are spent just trying to explain what the invention does. The trial record is enormous. Both sides spend a tremendous amount of money fighting the case. The court ultimately rules for the plaintiff after much time. The defendant appeals to an intermediate appellate court, and that court is concerned that the trial court didn't adequately address some arcane area of patent law. So it sends the case back down to the trial court to litigate that issue, another few months, back up to the appellate court, and reverses again and finds for the defendant. The plaintiff petitions to the U.S. Supreme Court to hear the case. It accepts, and the parties spent countless hours writing briefs, trying to get outside help, and try to write amicus briefs and other things to the Supreme Court, try to give the court a full picture of what's going on here. Finally, oral arguments. 10 years have passed since the plaintiff has filed his original complaint. During the arguments, and almost out of the blue, Justice Scalia leans forward and asks, "Why was there subject matter jurisdiction in this case?" The hush falls over the court, and no one has a good answer. The case is going to be dismissed. Doesn't matter how much the plaintiff and the defendant together protest. They want an answer to the dispute. It doesn't matter. Again, because the injury is not to the plaintiff or the defendant. The injury is to society. The injury is to the system. And the parties can't concede that injury. When we talk about subject matter jurisdiction in a first-year law course, and in most contexts thereafter for that matter, we're talking about limitations on access to the federal courts. But subject matter jurisdictional limits exist in certain state courts as well. When you study for the bar, you might have to learn some of them. And some law schools may cover local state subject matter jurisdictional limits as they relate to the particular area in which your school sits. But we're not going to cover those in this lecture. We are going to talk about 2 areas of federal subject matter jurisdiction, arising under and diversity. They are by far the most common, and are all that the typical first-year civil procedure law course will cover. We're going to start with arising under jurisdiction.